The last candidate to be interviewed this morning, Your Honors, is Court of Appeals Associate Justice Japar B. Dimaampao. Justice Dimaampao.
Good morning, Justice. Please sit down. And so may we request Attorney
Thank you, Your
Cayosa
Honor.
to start the public interview with respect to Justice Dimaampao.
Good morning, Your Honors.
Thank you, Justice Gutierrez. Good morning, Justice Dimaampao.
Good morning to Your Honor.
Yes, the records show that you applied for the Supreme Court in 2010.
That's correct, Your Honor.
And we have had several openings, maybe about 6, since the time that you last submitted your application.
That's correct.
What made you decide to apply again this time, and why the hiatus for 6 years?
First of all, Your Honors, there are 3 endorsements. The first one is an endorsement by retired Justice Romy Calijo for the vacancy that may be caused by the retirement of Justice Jose Perez. The 2 other endorsements pertain to the vacancy that may be caused by the retirement of Justice Brion on December 29. As can be gleaned from the endorsement of Governor Mujib Hataman of ARM and his Alliance of Muslim Advocates of Law, they made mention about that provision in the Tripoli Agreement, the Peace Accord of 1996, the original Armed Law and the expanded Armed Law Republic Act 9054, which consistently provide as a matter of state policy that there must be one representative, Muslim representative in the Supreme Court. Your Honor, if I may be allowed to expand on this, we have been deprived of Muslim representation in this court for 26 years, 21 years to be exact, because the last Muslim justice was Justice Bidin, who retired in 1995. Allow me to state in particular my profound desire that emboldened me to accept these 3 nominations. I came across a very erroneous decision of the Supreme Court on Sharia. I even memorized the case Mundaji versus Mundaji, volume 371 of Class 642. You can ask, Your Honor, please, any expert on Sharia. They are one in saying that the decision is very erroneous. In just the case should have been resolved applying Sharia. But with all due respect to the Supreme Court, it erroneously applied the civil law. Your Honor, that's the one that emboldened me to accept these nominations, because I believe that this injustice will continue if cases on Sharia will not be resolved in accordance with Sharia and Islamic jurisprudence.
Thank you, Justice. But I believe that that law that you are citing with the creation of the Sharia, particularly the Sharia Appellate Court, has been in effect for quite some time, even during the time that you previously applied. So I'm just wondering why if that is your explanation, that you feel that there is need for a Muslim member of the bench, particularly in the Supreme Court, that and it is only now that you have applied for the position. At any rate, you mentioned the Sharia courts. The Sharia Appellate Court has yet to be organized. Do you believe that there is necessity for the Sharia Appellate Court, considering that there are only a very few number of cases pending before the Sharia courts?
Yeah, Your Honor, please, there is such a law creating the Sharia Appellate Court. It has not been organized for a simple reason that there are no applicants, as it has to comply with the minimum number of applicants under the Constitution. Article 8, Section 9, at least 3. So that has to be complied with. At present, there is that circular of the Supreme Court transferring, in the meanwhile, the jurisdiction to take cognizance of appeal cases in Sharia to the Court of Appeals of Cagayan. Now, Your Honor, please, with all due respect, it's a fact that there are few Sharia cases, but the fact remains that cases involving Sharia must still be resolved in accordance with Sharia. In accordance with Sharia, so it's the clamor of my Muslim brethren that this Sharia Appellate Court is about time to accept, with all due respect, applicants, because I was told that they are really interested to apply.
Truth to tell, it has not even been organized. So there is nothing for the JBC to open. And therefore, we could not determine if there are sufficient applicants since we have never opened the vacancy, simply because the Supreme Court also has not organized it, there being no urgent need. So do I take it that should you be appointed to the Supreme Court, that you would push for the organization of the Sharia courts, the Sharia Appellate Court?
By God's grace, Your Honor, I will try.
Is it also a factor for you to consider the accepting the nomination, or rather the recommendation for you to be considered for the vacancies of the Justice Perez and Justice Brion, the fact that you all come from Mindanao, where the President also hails from, and that do you feel that this is an advantage and you would have better chances then of being appointed should you be nominated?
Yeah, it's a reality that the President hails from Mindanao. It's also a fact that the President has a Moro blood, or Muslim blood. I think it's just one of the factors. It's just one of the factors that impelled me to accept those nominations. Because to me, there is a glimmer of hope, unlike before.
Thank you, Justice Dimaampao. Let me just adopt one of the questions tweeted to us. How do you view the credibility of the current Supreme Court?
The present Supreme Court has earned the respect of the Filipino people. It resolved and decided cases in accordance with prevailing jurisprudence, taking into account the applicable facts of the cases.
Do you agree that that position has been maintained, or like that view has been maintained given the recent events, particularly with respect to the Marcos burial case?
With your indulgence, Your Honor, given that there are pending motions for reconsideration, I have to withhold my view. But let me state this, as every student of law knows this. There is this pronouncement of the court in the case of Albert versus CFI of Manila III, in that 1968 case, the court said, unquote, the Supreme Court by tradition, and in our system of judicial administration has the final word on what the law is. It is the final arbiter of any justifiable controversy. Some may have different views, but we can also call to mind what Justice Robert Jackson of the Supreme Court called the Supreme Court is final, but it is not infallible. It is infallible because it is final. Close quote.
Thank you, Justice. Now,
Thank you, Your Honor.
since you do not want to comment on that, perhaps you might want to comment on the current moves in Congress to restore death penalty. What is your personal view on death penalty?
My view is anchored on what the Constitution says, specifically Article 3, Section 19 of the 1997 Constitution, which allows the imposition of death penalty upon compelling reasons involving heinous crimes. So as lawyer, if Congress will pass a law based on that constitutional parameters, that's a valid law, which may be questioned, of course, by some of who do not agree with the same. So those are the constitutional parameters. Congress may thereafter pass a law imposing heinous crimes, and this must be premised on compelling reasons. I'm in favor if the constitutional parameters are complied with, Your Honor.
With that, that was my last question, and I wish you luck.
Thank you, Your Honor.
Thank you, Justice
Thank you, Your
Dimaampao.
Honor.
Thank you so much, Attorney Cayosa. May we request Attorney Mejia to continue?
Thank you, Madam Chair. Good morning, Justice Dimaampao.
Good morning, Your Honor.
Let me briefly take advantage of your known expertise in taxation by asking you one or two questions in that area.
My pleasure. My pleasure, Your Honor.
If there's any area in our present taxation system that you think should be improved or laws to be amended, what would those areas be?
First of all, we have good tax laws. But my humble view is that this must be strictly enforced. With all due respect, there are lapses in the implementation and enforcement of these tax laws. Be that as it may, let's attune to the changing times. As I have attached to my application, my piece on Philippine tax system, shifting gears. Since it could hardly meet the revenues, the target revenues of the government, it's about time to examine the provisions. I discussed the advantages of the present income tax system, that's the net income tax system vis-a-vis the gross income taxation. There are so many deductions, as you can find in Section 34 of the National Internal Revenue Code. It's my humble opinion that it's about time to reduce that. It's about time to reduce that by two deposits of a law. There are also many exclusions under Section 32B of the NIRC, it's about time to reduce those exclusions. So if exclusions are limited, the inevitable effect, we can generate the needed revenues. So, Your Honor, let's try to examine the provisions on exclusions and exemptions, specifically Section 32B and Section 34 of the National Internal Revenue Code. And then improve, let's be strict on the enforcement of tax laws. Apply strictly the requisites laid down under Article 254 and Article 255 on tax evasion.
One of the more controversial issuances made by the previous BIR commissioner is the imposition of a value-added tax on homeowners association dues. In your opinion, is that legal or illegal?
My humble opinion, Your Honor, boils down on the requisites of sale of services under Section 108 of the National Internal Revenue Code. It's basic that to be subject to value-added tax, there must be continuity, regularity of that transaction in sale of services. So if there is no continuity, regularity, and it's not made in the course of trade or business, that cannot be the subject of value-added tax. So since this association does not engage in the sale in the course of trade or business, my humble view is that that's not subject to value-added tax.
Thank you. On another area, what is your stand on mining?
Mining law, are you referring to that, Your Honor? My humble take on the same is anchored on Article 2 of the Constitution. That there are constitutional parameters or guidelines that may be complied with as long as they are complied with. I see no legal impediment to such passage of an amendment to the mining law.
May we also know your view on the allegations that of the extrajudicial killings prevalent today?
Let me start with this, Your Honor. Extrajudicial killings or extra-legal killings are committed without due process of law, without legal safeguards, without judicial proceedings. So, with that definition, they have no place in our democratic system.
Again, another question, tweeted question. In the Angladlad case, the Supreme Court reversed COMELEC's decision as it cited biblical and Quranic verses. How will you balance your religious belief with the need to decide cases using public secular standards?
As magistrate, I have to uphold the supremacy of the Constitution. Of course, under Article 3, Section 4, there is such free exercise of religious profession and worship. So, we have to strike a balance there. So, it's one of the constitutional rights enshrined in the Constitution, Article 3, Section 4, the state must respect that. So as long as that is not violated, I have to take to heart the magistrate oath, and that is to apply the law fairly and equitably without fear or favor.
That is the final question. Thank you and good luck, Justice Dimaampao.
Thank you, Your Honor.
Thank you, Madam Chair.
Thank you, Your Honor.
Thank you so much, Attorney Mejia. May we request now Judge Ilaw to continue.
All right, thank you, Madam Chair. Good morning, Justice.
Good morning, Your Honor.
How are you today?
Good. Thank you.
At any rate, this is just a follow-up question from a Twitter regarding your view as to the credibility of the current Supreme Court. And this is followed by the question, what will make you different if appointed from the sitting justices of the Supreme Court?
I have high regard for the present members of the Supreme Court. With all humility, I can bring to court my integrity. With all humility, I can contribute in enriching jurisprudence on Sharia, taxation, and commercial law. Given my stint with the academy for 25 years, I can bring that wealth of knowledge to the court.
All right, as member of the judiciary, academe, a bar reviewer, and an author of various books and subjects regarding the law, what changes would you effect in the bar examinations as to help aspiring lawyers to become lawyers, or rather aspiring lawyers, and address the increasing demand for lawyers, while at the same time maintaining or improving the quality of lawyers in this country produces?
But based on my experience, Your Honor, please, as professor of law and bar reviewer, and on the basis of the feedback from the bar examinees law students, allow me to pronounce these possible reforms in the bar examinations. One, avoid surprising or shocker questions. Number two, focus on basic questions. Three, ask questions based on settled jurisprudence, significant jurisprudence, or jurisprudential rulings of the court. And fourth, based on my experience as bar examiner in civil law in 2013, it is ironic to say that bar candidates should have equipped themselves with this good command of English language. I passed only 24% of the examinees in civil law, and I tried to examine the reasons why only 24 passed, and I discovered that of these 26% who failed, majority of them could hardly express themselves in good English.
All right. Thank you, Justice.
Thank you, Your Honor.
All right. What do you foresee will be your contributions to the Muslim community, which has earnestly supported your nomination to the Supreme Court as an Associate Justice?
Your Honor, as I've mentioned a while ago, that there is that erroneous decision in Sharia. The case of Bondaji versus Bondaji promulgated on December 7, 2001. To me, that's an injustice to the Muslims in this country. So, by God's grace, if I will be appointed to the court, say, by God's grace, I can help the court with all humility in avoiding erroneous decisions on Sharia, which will eventually amount to injustice to the Muslims in this country. I can be of help in preventing such possible influx of decisions which are not resolved in accordance with Sharia and existing Islamic jurisprudence.
All right. There's another Twitter question. In what other decisions do you think the Supreme Court made a mistake? For example, Enrique Bail. Enrile Bail.
Well, let me have this premise. As I previously said, the Supreme Court is the final arbiter of any justifiable controversy. If I advance a view, it has no bearing at all. I mentioned that Bondaji versus Bondaji, and in tax cases, there are decisions which are not in accordance with existing laws, but they are still there. They are still there, and it's so unfortunate that there are conflicting decisions. There are conflicting decisions on tax cases. I come across 4 conflicting decisions on tax cases. It's about time to reconcile the same.
All right. Thank you again. I may not been privy to the previous applications of yours, and that on the record shows that an opposition from a concerned citizen had been made, calling the attention as to the alleged alarming backlog of your cases. And can you elaborate further in explanation regarding the said opposition?
Your Honor, that was in 2009. I have answered that. Let me state for the record that I have only 21 cases submitted for decision. Of these 21 cases submitted for decision as of last week, November 2016, 13 to 15 cases are the normal number, raffled off to us. I have disposed of 2,798 cases since I assumed as Associate Justice of the Court of Appeals in 2004. And based on the report of our statistics, there were only 7 reversals. So again, Your Honor, since that occurred in 2009, and I have responded to that to a ratio of my present backlog, I have only, again, for the record, 21 cases submitted for decision.
All right. In your letter of application, you claim to have specialized in commercial law and taxation. How about criminal cases?
Your Honor, as a former regional trial court judge of Mandaluyong, I have handled a lot of criminal cases. Besides, prior to my appointment to the judiciary, I was a senior state prosecutor of the Department of Justice. So we investigated a lot of criminal cases.
How about civil law?
I taught civil law review when I was a regional trial court judge of Mandalay.
And lastly, about remedial law.
As Associate Justice of the Court of Appeals, we apply the existing rules on procedure. So we, with all humility, I have gained experience about the application of the existing rules and procedure.
All right. Thank you very much. And no further questions. Good luck,
Thank you, Your
Justice.
Honor. Thank you, Your Honor.
Thank you, Judge. Good morning again, Justice.
Good morning, Your Honor.
Okay. You stated a while ago that
Mundaji.
Montaji versus Montaji is erroneous. Okay. Can you enumerate 3 or 5 decisions of the Supreme Court you consider erroneous? This is a free country. We can comment. As what you said, we should abide, respect the decision of the Supreme Court, but we can criticize.
Let me start with this premise, Your Honor. The Supreme Court is the final arbiter of any justifiable controversy.
Given.
My opinions have no bearing, but since you are asking me, I think I may.
Even
aside
3
from-
only. 3.
Three.
Not 5.
3, the Bundaji case, with all due respect to the court, as that is, as the Supreme Court has spoken, Article 4 of the Constitution enumerates those who are considered citizens of the Philippines. I see no...
1935 Constitution,
Yes.
applicable to Grace Poe.
Since you mentioned that case, I'm about to mention that, Your Honor.
Don't be hesitant, Justice.
Article 4, which is also the reproduction of the article on citizenship under the 1935 Constitution, it defines the meaning of natural-born citizen. One which is not required to perform an act to acquire or perfect his citizenship. Well, the majority view enunciates the principle of presumption of natural-born citizenship of foundlings. If we try to examine the provision,
This is highly violative of the Constitution.
I find no clear basis under Article 4 of the Constitution. That's just my view, Your Honor. Well, that presumption may be find support in international law, but it is our Constitution that must prevail over settled principles on international law.
I agree. Two more.
Two more. My opinion, again, has no bearing. As the Supreme Court has spoken, but this is a tax case, Your Honor.
Not a tax case, but landmark decisions concerning the entire country, the Filipino people. And Senator,
So aside from the issue on citizenship, the case of the Castro versus JBC
case of
needs to be revisited. That's the clash between Article 7, Section 15 of the Constitution regarding election ban with Article 8, Section 4, Paragraph 1, the second sentence thereof. The prevailing view, in effect, abandoned the doctrines laid down in the case of Villanueva and Villacorta. With all due respect, that requires
so the decision of the Supreme Court in the Corona case is highly erroneous because he was appointed within the 2-month period prior to the national election and until the end of the term of the president. I agree also with you.
Let me state clearly that that's the prevailing jurisprudence. So we have to abide by that. What I am just saying is it may be the subject of re-examination in the near future.
Can you mention one more or two?
The IDCA case. Let's consider the view of that late legal luminary, Senator Miriam Santiago. Her view is that has to be concurred in by the Philippine Senate. That Enhanced Defense Cooperation Agreement.
EDCA.
That's the case. That's really the case of Sagisag versus Ochoa Jr.
EDCA is a bilateral agreement between the Philippines and USA.
That's why.
And EDCA, according to the Supreme Court, is a mere implementation of PFA. So you are dissenting. Why?
What I'm saying is, since he's a legal luminary, let's try to examine. Let's have an in-depth analysis of the review.
May I ask, what is the difference between VFA and EDCA in the first place? Visiting Forces Agreement.
Enhanced Defense Cooperation Agreement.
According to you, they are two different things?
That they are inextricably linked to the Mutual Defense Treaty of 1951.
51, yes.
These are just implementations. On that basis, the Supreme Court ruled that
The
it's
one
unconstitutional.
implementing is only the EDCA, implementing BFA.
Yes, Your Honor.
So according to you, EDCA must have, the Senate must have approved EDCA.
I'm just echoing
Two-thirds votes.
the
Because to you, for you, that is a treaty, not a bilateral agreement.
I am just echoing the view of that legal luminary,
And that is also review, your view.
which has no bearing at all because there is that final decision of the
Another case, justice. No more?
a tax case, but I cannot recall
Not
of
tax case, that is highly technical. Going back to tax case, can you recommend, make a position paper to Congress that our income tax, should be reduced from 32% to only 20%?
Your Honor, there are constitutional limitations on the exercise of the power of taxation. Congress must always...
Can you not make that as an exception? You are a brilliant tax
No.
expert.
I don't have a monopoly of knowledge. This is just a wisp of knowledge given to me by Almighty God. It's basic under Article 6, Section 28, Paragraph 1 of the Constitution, that the rule of taxation shall be uniform and equitable.
Uniform
The
to all of
Congress-
us income earners.
or-
All of us here in the audience.
So as long as Congress has complied with that, there is nothing wrong or constitutional infirmity in such law. Yes, by lowering the rates, that may be consistent with the principal rule on equitable taxation.
That is equitable justice, 20% only. Okay, another question, Justice. Can you mention 3 or 4 flip-flopping decisions of the Supreme Court?
With all
Even if the decision has
With
become
all-
final and
with
executory, and
with
yet
all-
the Supreme Court changed its mind.
with all due respect, Your Honor, if my memory serves me right, the cityhood case, the court made
How many times
flip-flopping
did the
decisions.
Supreme Court flip-flop?
The other case, I may be wrong.
Times. The Supreme Court flip-flop in Dinaga, in cityhood.
Yes, that's the next one. That one in Surigao.
Piscapio said
del
the
Norte.
16 laws are constitutional. Then Justice Velasco said unconstitutional on the part of Justice Carpio. Then Justice Velasco said unconstitutional. And then Justice Bersamin, what was his ruling? There was really flip-flopping. Another decision, Justice.
Dinaga,
There are several.
The
That's why when you go up there, you should take action so that there will be no more erroneous and flip-flopping decisions. Promise.
I will always be guided by the magistrate's oath, Your Honor, to dispense justice fairly and equitably without fear or favor, guided by the pursuits of law and jurisprudential teachings of the Supreme Court. I will do that, Your Honor.
Another flip-flopping case from cityhood.
Your Honor,
No, we are discussing the decisions here.
those are so far the cases that I could recall.
Only the cityhood. Okay. How about Dinagat?
That's, I think, another. I mentioned that
Province.
Province. of Surigao del Norte.
This 16 municipalities. This one is Dinagat province. Another one is PASAP, versus PAL. Flight Attendants and Crew Association of the Philippines versus PAL. They also flip-flop. Okay, another question. What do you think is the most disastrous decision ever rendered by the Supreme Court? The Filipinos' freedom, liberty.
At this moment, cannot think of most disastrous decision with indulgence of Your Honor.
You are a very intelligent magistrate. You studied this during your law school days. Haviliana versus
Yes,
Executive
yes,
Secretary, wherein the Supreme Court ruled that there being no more obstacle to the constitutionality of Marcos Constitution, it is now in effect. And that extended or validated martial law. So if there is history, of the decisions of the Supreme Court, that can be considered as the most disastrous. But what is the counterpart decision in America? The most disastrous decision ever rendered by the U.S. Supreme Court, which precipitated the civil war between the North and the South. You also studied that during your school days.
I cannot recall of one.
Fred Scott versus Stanford,
Yes,
remember?
sir.
Okay. Let's go to another constitutional provision. Recently, President Duterte said that he would issue or will issue an executive order suspending the writ of habeas corpus, I think in Mindanao. What is your comment on?
Your Honor, since as magistrate, I am always aware of my judicial task, and that is to uphold the supremacy of the Constitution. The President must comply with the constitutional parameters and guidelines set forth in Article 8, Section 18 of the Constitution. Allow me, Your Honor, to enumerate these legal parameters.
You can recite the provision.
There are 6 paragraphs there, Your Honor.
The first paragraph.
It-
President is the commander-in-chief.
Yes,
Okay, go ahead.
The President shall be the Commander-in-Chief of all armed forces of the Philippines, and when it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion, period. In case of rebellion, in case of invasion or rebellion, when the public's safety requires it, the President may suspend the privilege of the writ of habeas corpus. And then it further provides that the suspension must not exceed 60 days. The other constitutional parameter is that within 48 hours from the suspension of the privilege of the right of habeas corpus, the President shall report in person or in writing to Congress. The provision further states.
Include martial law. After that.
But your question, Your Honor, dwells only on suspension.
I'm asking you to recite Section 18.
Okay. So it covers the declaration of martial law or entire country or part suspension of the rate of habeas corpus. So those constitutional parameters that I have said apply to
The
declaration
question
of
now,
martial
Justice,
law.
is can President Duterte suspend the writ of habeas corpus
Yes, if
on the basis of what is happening now in our country, especially in Mindanao, as what he said?
he has, Your Honor, to comply, adhere to this constitutional limitations or parameters, because in paragraph 3 of that section 18 of Article 7, there is this new provision inserted by the commissioners of the Constitutional Commission. The Supreme Court may review in an appropriate proceeding filed by any citizen the sufficiency of the factual basis of the declaration of martial law or the suspension of the rate
Yes,
of
yes,
habeas
Justice, I
corpus.
agree with you. There are safeguards. So in other words, there are three kinds of actions on the part of the presidents which are graduated. The
Yes, sir.
first is calling out power. Do you think Senator Lacson was right in saying that by the action of the president, he has weakened the PNP and Armed Forces of the Philippines? Meaning to say, instead of going directly to the suspension of the rate, he should have first called the Armed Forces of the Philippines. Did he do that?
That's what the Constitution
And
says.
then, yes, and then suspension and then martial law. So 3 stages in case of invasion, rebellion. In
With
the
the
first
public.
place, in case of lawless violence, invasion, and rebellion. Anyway, thank you very much, Justice.
Yes.
Good luck.
Thank you, Your Honor. Thank you, Your Honor.
Hope to see you in the Supreme Court
Only
and
God
hope you
knows.
can correct
Thank you, Your Honor.
their mistakes
Thank you.
and
Thank
their
you.
flip-flopping.
Thank you so much for this opportunity. Thank you very much, Your Honor.